Hi, Dara. How are you?
I'm doing well, thank you.
Before we get started, if you could just introduce yourself.
Sure, my name is Dara Purvis. I am currently a professor at Penn State Law, and I study gender, sexuality, gender identity, and the law.
Fantastic. You are a feminist legal scholar, and as you said, you specialize in family law. You've written about the challenges faced by transgender and non-gender conforming youth in school. And I would imagine there is a strong connection between education and family when it comes to LGBTQ plus children and adolescents. So, could you go into a little bit more detail, just kind of based on your scholarship, about what trans and non binary students and their families face in educational settings? And then, kind of as an extension of that, how you've observed, like what you've observed about the law's response to how our culture has shifted in its view of gender as a construct.
Something that I have written about recently is how schools send a lot of messages around sex and gender to children. And this isn't all explicit teaching. I'm not saying that teachers are typically saying in the classroom, there are two genders. They are important ways that we divide people. Sometimes they can. There are some truly appalling examples from abstinence-only sex ed programs that do give these gender stereotypes and talk about how men are knights in shining armor and women are princesses who shouldn't tell a knight what to do. But most of the time, what I'm talking about is implicit messaging, that there are two genders, that we should be able to easily identify the gender of every person, and that includes ourselves, that this is an important difference, and that it makes sense to divide people by gender. So if you think about things like dress codes that are written differently for girls and boys, bathrooms, locker rooms at school that are labeled girls and boys, and of course, sex segregated sports. All of these communicate messages about gender. A trans child or a non-binary child who is sitting through all of that messaging, number one, maybe that child is still figuring out what their gender identity is. And they're getting a message that where they think they should be, who they think they are, and who the school thinks they are may be different. So this could certainly cause internal struggle and maybe some questions for a trans or non-binary child. But let's say that this child is able to express, I am transgender, I am non-binary. They tell their parents this, and their parents are supportive. Now their parents have to go to the school and say everywhere that this happens, whether it's which bathroom they use, the pronouns that you use to refer to them, what clothing they wear to school, all of these aspects of their day, we would like our child to do this differently than what you are currently expecting from them. And depending on the school and the school may or may not be willing and able to do that and to allow the child to go about their day in the way that they would like. Now, on the one hand, there is a federal statute that forbids sex discrimination in schools, Title IX, and it has been read by recent Democratic administrations to forbid discrimination on the basis of gender identity. And this is consistent with the recent Supreme Court ruling in Bostock v. Clayton County that similar language forbidding sex discrimination in the context there of work protects employees against discrimination on the basis of their gender identity. So there's some legal support, there's considerable legal support for a parent who says, I would like you to support my child in their gender identity. But there are also many areas of the law where the Supreme Court has said that biological differences between the sexes are relevant for the law and they're benign. in the sense that it doesn't violate the Equal Protection Clause for federal laws to make distinctions and treat people differently according to whether they're male or female. So from that point of view, treating sexes differently, treating them as important categories, doesn't necessarily always mean that there's discrimination going on. And specifically in the context of children and in the context of families, the law and political arguments are often more conservative and more willing to credit gender stereotypes, more willing to see significance of sex differences. Some of the most explicit sex discrimination that the Supreme Court has said is constitutional happens in the context of parenting, in deciding who is a legal mother and who is a legal father. Courts at all levels for a very long time were willing to say, we need to protect children, and all the scare quotes I can imply there around protect. We need to protect children from a gay parent or a transgender parent. And today there is a really strong movement towards saying that parents who recognize that their child is transgender and affirm their child's gender identity are committing child abuse. And parents who are being supportive of their child in this way, this should be a reason to potentially take a child away from their parents. So while there has been a lot of progress in the law to try to recognize and eliminate discrimination against trans people, it's been very imperfect progress and very uneven, depending on the context and depending on the questions involved.
And in the educational context, just to elaborate that on that a little bit more, is there tension between the protected interests of individual children, kind of clashing with the protected interest of the children collectively, if that makes sense?
Certainly, many people have tried to argue that asking to affirm, to recognize, and to accommodate a trans child affects the rights of other children. Those arguments are not always super clear about what exactly the right of the other children is. So sometimes you get into the more specific contexts, like we're talking about sports, and I'm going to talk specifically about what those arguments can look like. Sometimes it's an argument around privacy. Mm-hmm. So I've seen arguments that cisgender children have a right to privacy in the bathroom, whether it's I shouldn't be seen by someone who I am saying is a different gender than myself, or my right to privacy includes the right to not see the genitals of someone else that is a different gender than myself or a different sex than myself. I will say that what that argument looks like, number one, often turns on saying that a trans child is not, again with scare quotes, really the gender of their gender identity. So it is often based on an assumption that a trans girl, for example, is not really a girl. So it assumes a little bit, it assumes a lot of the argument that it's relying on. And also, these arguments are not versions of a right to privacy or an expression of a right to privacy that we've really seen very much. So we don't typically talk about a right to privacy in a public bathroom. We understand that it's not a completely public setting, and there have certainly even been cases about search and seizure and expectations of privacy in public bathrooms. But this isn't a super clear right that has been articulated many times. So it's different versions of a right to privacy that are employed to say, this is what I want to set against the right of a trans child to have educational opportunities.
Right. And those court cases, specifically the bathroom ones, have been, and you talk about this in your writing, been largely unsuccessful, right? It hasn't really been a successful argument, at least not at like the appellate court level. And I can link to some of those decisions too. So what's interesting to me then is how this changes a little bit when we get into the space of athletics, right? So, in your book chapter, you go into a lot of detail about how school districts have handled trans students in a variety of different contexts, including athletics. So, can you give us a sense of the foundation on which this present debate about transgender, transgender student inclusion in scholastic sports rests? I'm interested in your thoughts on, how this current debate is building on past challenges to gender-based exclusion from single-sex teams, and how you think this kind of informs or affects the current conversation.
When you look at political and legal arguments around trans students in schools, there are three questions that come up over and over again: dress codes, bathrooms, and sports. When I started my research, there weren't too many examples of court cases, litigated cases, where a trans student had sued in order to be able to join a sports team that was consistent with their gender identity, particularly examples of younger students doing this. But there is already a body of older cases from the 1970s dealing with single-sex sports teams where a cisgender student, usually but not always a girl wanting to join a boys' team, had brought those kinds of claims. And you see the exact same arguments in those cases as we see in today's arguments around trans students, which is this isn't fair and this isn't safe. Yet in the 1970s, you saw many courts rejecting these arguments. The fairness argument, as articulated in the 1970s, was if we allow boys to play on girls' teams, that will be unfair because the boys will dominate the girls. They will do better. Today, that argument is if we allow trans girls to play on girls' teams, the trans girls will unfairly do so much better than cisgender girls. They will take opportunities away from cisgender girls. Several courts in the 1970s basically just said, why do you think that? Do you have any facts to show that these girls' teams will actually be taken over by boys if we allow this one boy to play? So one example of this happened in Massachusetts. At the time, there was a rule that if a girl wanted to play soccer, but her school didn't have a girls' soccer team, she could join the boys' team in order to be able to play. But a boy in the same position whose school only had a girls' soccer team couldn't join the girls' team. And when that rule was challenged, the Massachusetts Interscholastic Athletic Association said, well, we have to make this one-sided. Because if we let boys play on girls' teams, those teams will be swamped by, and I will quote here, boys of skill and prowess superior to those of girls. But the Massachusetts court said, you haven't given us any evidence to show that that's going to happen. We don't want to base a ruling on this assumption that you've given us nothing to back up. Another example was in Rhode Island. There, it was a male student who had transferred schools, and he had played volleyball at his old high school, transferred to a new high school that only had a girls' volleyball team. Again, he asked if he could join it. He's told no. The coach and his school said, well, if volleyball becomes popular among high school boys, they would dominate a co-ed team. Girls will lose out on all these opportunities. But the district judge, again, ruled in the boys' favor, in part because the school hadn't presented any evidence that letting him play would mean any other boys at the school would also want to play and swamp the team. Now, compare that to today, a state like Utah. Utah passed a ban on trans girls playing sports over the veto of Utah's Republican governor, Spencer Cox. And in Governor Cox's veto message before the legislature again passed it, he pointed out the numbers. So there are 75,000 high school students in Utah who play sports. 4 students in the entire state who play sports are at the high school level are trans. Only one of them, one student out of 75,000, is a trans girl. So just as courts in the 1970s said, you haven't put anything before us to actually show that this will result in girls being pushed out of sports, these numbers just don't add up to an argument that cisgender girls will be pushed out of sports opportunities either. The other objection that we see today has to do with safety. In the 1970s, this was, if we allow boys and girls to play sports together and against each other, the girls will get hurt because boys are bigger and boys are stronger. Today, this argument is trans girls who went through puberty and developed secondary sex characteristics of the sex that they were assigned at birth are bigger and stronger than cisgender girls, and thus cisgender girls will be hurt playing sports with and against trans girls. It's definitely true that at least in some sports, playing against a bigger person may increase your chance of injury. But again, as courts pointed out, when this came up in the context of girls and boys, schools and sports teams were using sex as an inaccurate proxy if what you actually want to get at is body size. For example, a number of courts pointed out, hearing these cases about boys and girls in the 1970s, smaller boys might be injured playing sports against larger boys. And particularly when you're looking at teenagers, you've got kids at various sizes, at various stages of puberty already, big variations in size. But none of these teams, none of these schools who were saying we can't let girls play because they'll get hurt, told smaller boys, we can't let you play because you, smaller boys, may get hurt. And if what you're concerned about is the size of the students, sex isn't always accurate to tell us their size, particularly when we're talking about younger students. There was one case out of New Jersey where some girls wanted to play on a little league team, and the team said, no, we can't let them play because the girls will get hurt. And an expert witness pointed out, we are talking in this case about 8 to 12-year-olds. At that age, girls and boys are about the same size. If anything, girls are often bigger. So to the extent that you're concerned about size and safety, using sex as a proxy for body size just isn't all that helpful and isn't all that accurate. Today, similarly, using sex assigned at birth as a proxy for body size doesn't tell us what we're actually concerned with. And the focus on sex assigned at birth, while ignoring different sizes among cisgender students, highlights, I think, in the same way as it did 50 years ago, that maybe this isn't what is actually motivating people.
Right, in passing state legislation, absolutely. So, when you consider the regulatory amendments that are being proposed by the Department of Education, one thing that caught my attention as I was reading through the rulemaking documents was this explicit assurance that Title IX recipients, so largely schools, right, in this case, would maintain the ability to make policies about athletics and participation in athletics that take fairness and safety into account. So you've highlighted, right, some of the problems with this, with these as the basis for exclusionary policies in the past. Do you see a possibility that this past history of litigation will inform how policies are evaluated presently, or Or does the fact that fairness and safety were included in the rulemaking documents as these important considerations suggest that not much has been learned from that experience?
It will be interesting, I think, to see what the final regulations look like, but I am concerned at how much of a door the regulations, at least as they are initially drafted, how wide that doorway is to usher in kind of the fairness and safety justifications as an excuse for really broad exclusion. So the new regulations say if a school wants to limit sports participation based on the sex that a student was assigned at birth, that limitation must be substantially related to the achievement of an important educational objective and minimize harms to students whose opportunities are limited. So we already know, as you've said, that the objectives that are offered by people trying to ban trans students will be fairness and safety. And there's no question, fair opportunities and keeping student athletes safe are important objectives. Absolutely no question with that. So the open question is, what is the relationship between sex assigned at birth and fairness and safety? So from my perspective, it seems pretty clear that this is an imperfect relationship at best. And that's why I think it is so helpful to look at these cases from the 1970s, because it gives such a clear example of how you say, well, you're just assuming that there is a relationship here. If you are saying it won't be fair and it won't be safe, you have to give us some facts to show that this is going to actually impact fairness. And this is actually the best way for us to ensure the safety of student athletes. The regulations say we recognize fairness and safety as important. We received feedback from stakeholders about these concerns. And the document does at least paraphrase some of the arguments that say, if you are concerned with these things, using sex assigned at birth as a proxy is not an effective way of ensuring fairness and safety. There are more specific and more tailored ways to do that don't involve these very broad and across the board bans. But at least as it's currently drafted, the standard seems to allow for a lot of exclusion based on those concerns that again, I think may or may not have any link to gender identity. But it kind of provides a framework to say, well, we all agree that these goals are important. And these are things that we do want, safety and fairness. And if you can sort of say strongly enough or just phrase your arguments to raise these concerns, it seems like that creates a viable excuse for a broad ban.
Right.
I would hope that the Department of Education and even individual school boards and legislators would recognize that these are imperfect fits, that there are much better ways to talk about fairness and safety. And there are important reasons, there are important things that are good about sports that we should want trans students to participate just as much as cisgender students do. But we already see a really strong anti-trans political movement in a lot of places throughout the country. We see a lot of variety, school by school, school board by school board, state legislature by state legislature, and how willing they are to try to essentially legislate transgender people out of public spaces. And I worry that this door is kind of open too wide, that so many schools and so many people are just going to frame bans using the language from the regulations, that it's going to be extremely difficult, extremely burdensome, and extremely unlikely that trans students will actually get much protection.
And let's actually let's flesh that out a little bit more for any non-lawyers in the room. From a practical standpoint, then, if a policy is enacted at an individual school district level that does put forth as a justification for, sex-based exclusion, fairness in competition, let's say, and a trans student is affected by that. And maybe there won't be a trans student affected by that for a little while, because as you pointed out, there may only be one trans student in an entire school district, in a period of years who wants to play sports. So, but then one comes along and wants to challenge that rule. Talk a little bit about then the burden on that student and that family and the barrier that creates for their participation in sports, let's say, during their high school career.
Sure. So say that you're a trans student, you may or may not already sort of be out as trans at school, depending on how long a student has been going to school in that district and so on. So first of all, there's just a question of, do I even want to kind of out myself? Say they're willing to do that. Now they and their parents would have to go to the school and say, it appears that there's this policy that would exclude me from whatever sports they want to participate in. They have to have some kind of meeting, confrontation, disagreement with the school saying, we think that this policy is inappropriate. Presumably, if they're going to continue to sort of pursue this, the school says no. So now the student is aware that, okay, the coach who I want to play for, the teachers and administration who I am still a student under, don't like that I'm doing this and disagree with me. And now I'm going to, in a completely legal way, kind of threaten them by saying, well, maybe we will try to file a complaint under Title IX. Maybe we are going to file a complaint against you. So again, you are telling the administration who is in charge of you, the coach you want to play for, that you're going to file this complaint. There is a long, just administrative process. These kinds of complaints can take considerable lengths of time, especially depending on how often this is coming up, how many complaints like this are going on or are being sent along to the Department of Education. So depending on the age of the student, if it's a high school junior or senior, it may not kind of be worth it from a time perspective because it may not even be able to be resolved while they're still eligible to participate. And if the Department of Education, on the one hand, they may say, okay, school, this policy is insufficiently specific. This is too much of a bar, just a blanket ban. We need you to do something else. Depending on how strongly the school wants to resist that, this could end up as a lawsuit. This could end up as the students suing their school district. So now this is a very public proceeding. It is likely we try to keep minors' identities anonymous in most lawsuits, but it is quite likely that this would become publicized. We have already seen students who have spoken up, for example, at school board meetings, their faces and names being publicized in their community and beyond. So now this student and their family trying to say we want to play sports are engaged in litigation, potentially, against their school district, which, number one, will cost the school district money. So you're weighing how much I want to play sports against how much is this going to harm the school community? How much of a burden in terms of time and potentially money is this going to be on my family? How is this going to affect my relationships with other students, with the school? How will this affect other things going on in my life? College applications, things like that. And you see a huge impact on this family and on this community that a lot of people very understandably would be hesitant to take on, even if they feel strongly that the school's policy is wrong. This is really taking a student who is already very possibly vulnerable and pushing them forward even more into kind of the spotlight, into conflict with the school. But one thing I'll also add to this, in addition to the trans students who are affected by these bans, cisgender students are affected too, in a way that they may not even initially be aware of, which is when school districts, when states have these really blanket bans against trans students playing sports, cisgender students, cisgender children whose appearance does not conform closely to their gender become the object of suspicion. Mm-hmm. So I'm sorry to pick on Utah again. They've just had a few recent news stories about this. But last year, Utah revealed that there was a cisgender girl who was playing sports. They haven't even revealed what sport she was playing. But other students' parents thought that girl's really good at sports, mm-hmm. and she's bigger than my daughter. I think maybe she's trans. Mm-hmm. And so I'm going to complain to the school and say this girl is not really, again, scare quotes, a girl. I think this is a trans girl. I think she shouldn't be allowed to play sports. And without the knowledge at the time of the girl, the school district investigated her gender. They went back and they tried to look through her school records to see, has she always been enrolled in school in Utah as a girl? Or was she assigned a different sex at birth? Can we determine whether there's something here? So this isn't going to just affect trans students. It's going to affect lots of children if there's any reason based on any kind of stereotype that maybe someone thinks that they could be trans. So it's going to have ripple effects throughout students and throughout sports.
Yeah, absolutely. And if we take, Olympic sports or elite level sports as any indication, that suspicion will often come down more heavily on girls of color.
Absolutely.
And, in other ways that echo our institutionalized racism and bias. So, I really appreciate you making that point, because it is a complex structure where when we leave the door open for gender to be policed, all gender then, right, is open for debate and assessment, yes. Right?
Yeah.
Oh, no, sorry, go ahead.
I was just going to say, gender is a racial concept. Gender is a classist concept. This is intersectional, and our ideas about what girls look like are often, it's a lot more than what chromosomes someone has.
So you make a really interesting point in your article about the downstream potential of, more universal inclusion of younger transgender children in athletics, or perhaps even just abolishing single-sex sports for younger children. Children at an age where there's very little compelling justification for exclusion of children based on fairness or safety. Could you go into a little bit more detail about that?
So I'm interested in gender stereotypes in a lot of different contexts, especially where I see the law reinforcing and contributing to those stereotypes. Mm-hmm. So I like thinking about, how do we learn about what male and female, or man and woman as categories are? What do we do consciously or unconsciously to teach children there are two genders? Here's how you start dividing people into boxes. And I will say I started doing this research before I was a parent. Now I'm the mom of 3 kids, and it has been brought home to me in very personal ways about how we start gendering children so early. I remember going for an ultrasound late in my pregnancy with my first child, who was assigned female at birth. The ultrasound tech was having a hard time getting one of the measurements that she wanted. And she said, "Oh, she's just not giving it up." Well, that'll be good when she's older, right? And I was lying there thinking, are we really sexualizing a 37-week-old fetus? But we were. That's how early it starts, even before birth. So if you think about younger children playing sports, these are typically not extremely competitive sports. So with some really rare exceptions, this sports participation, this is not already putting kids on a path to college scholarships or pro careers. So these are kids playing sports for a lot of the reasons behind why Title IX was passed and why Title IX has been applied in the context of athletics. They're playing sports for community. They're learning about teamwork. They're learning how to win and lose gracefully. They're learning how to move their bodies in ways that feel good. None of these things turn on the sex that they were assigned at birth. And if we're talking again about 8-year-olds, about young kids, we're not really worried about kids getting hurt. Again, outside of some really extreme exceptions, they're all pretty close to the same size. As anyone who has watched a child soccer scrum, my 4-year-old went to soccer yesterday. I am not super worried about her getting hurt. No one is going after the ball that aggressively. So what does it do to start saying quite early in elementary school, "Oh, we have to divide you into these gendered categories"? What does it do? What does it convey to children to say it's important that we have these 2 boxes and we put you in those boxes according to the sex that you were assigned at birth? It tells kids that this is important. As you learn to interact in the world, this is one of the first things that you need to know about someone. So my point is just the flip side of that. What if we didn't do that? What if we didn't categorize children as rigidly by sex and we let them all play together, or we just split them up by ability or by size or by random assignments into teams? I think that would send a different message that, sure, there are differences in our sexes and genders, but those differences aren't relevant most of the time. This is just something about the variety and diversity of the people that you interact with, and you can have teamwork and learn to have fun and learn to cooperate with all of these kids. And sex and gender are not the first thing that you need to know. And we're going to start teaching you to associate with people that you see as the same sex and gender as yourself.
And as you point out, it might be the start of really deconstructing the unconscious or implicit gendering in athletics of young children, right? That like some of the differences that we believe exist between male and female athletes may not be biological, because how can you know that when our entire, athletic system from, yes, I mean, my son played first grade basketball on a boys team. I don't know why. That's just how it was. It's starting to be ingrained in them from the very beginning, whether it's by the coaches, whether it's by the parents, or by the entire system, right? That there is some difference between the way a boy and a girl plays sports. And I think that's a really, really good point, is that so much of that difference is theoretically as attributable to socialization as it is to biology. Okay, so in that same article, you present the argument that First Amendment protection could extend to expressions of gender identity in school. That is, you raise that argument in a different context, but do you see any potential for this or other types of legal pathways to allow trans students to challenge exclusion from school sports if these new regulations become final and their school districts implement, legitimate sex-related eligibility criteria, and they don't want to go through this lengthy Title IX complaint process? Are there any other avenues?
I do think that there could be a First Amendment speech argument in the context of sports. There is a pretty obvious expressive element to labeling yourself by gender. Mm-hmm. If I sign up for a girls' sports team, I am expressing that my gender identity is a girl. And if my school or a sports association or a state law tells me I can only sign up for a boys' team, that could be understood as compelled speech. The school, the law, whatever policy is forcing me to express my gender identity as a boy. Now, obviously, this is expressive conduct. So it's not as isolated as some of the other compelled speech cases. The example of compelled speech that is probably the best known is a person in New Hampshire who said, "It is against my religion to make me use a license plate that has the New Hampshire motto, 'Live free or die,' on top." So the person who was challenging this said, "I'll use the license plates. I'm not refusing to register my car. I just want to cover up those words that are against my religious beliefs." In the context of sports, there is an expressive message of playing for a girls or boys team, but there isn't really a way to say, well, I'll play on the team you want. I just don't want to express this message. So courts haven't really grappled yet with questions of what happens when, on the one hand, you have a student who wants to express their gender, and on the other hand, you have a school or legislature or Department of Education saying, here are policy reasons we think that you shouldn't get to express that. In other contexts, courts, including the Supreme Court, have been very deferential to First Amendment claims. Just in this last term, the court said that the First Amendment rights of a website designer effectively outweighed a statewide non-discrimination law, that requiring a website designer to make wedding announcements, wedding websites for same-sex couples would violate that designer's First Amendment rights. But I think it's pretty clear that the current Supreme Court is not equally sympathetic to different kinds of expression. So I don't think that case represents a victory for free speech rights across the board.
It does suggest.
Go ahead.
It does suggest, though, that you could bring that claim even without a trans student actually being affected by the policy, since in that case there was no actual website that website designer had been asked to design for a same-sex wedding. So perhaps the wheels of justice might be able to turn a little bit more quickly. Sorry.
Yes, although I will also not defend the consistency of this court when it comes to standing requirements, but absolutely, I think it's a viable claim. I think it's a viable argument. I don't know that I have very high hopes that courts would assess those claims in consistent ways, but absolutely there is an expressive dimension to this. So this isn't just Title IX. Title IX is a really important statutory resource and attempted guarantee of equal treatment in school. But I think this also implicates a lot of other rights. I think it implicates expression rights. I think it implicates liberty rights. I think it implicates equality rights. So there are a lot of different avenues. And it's just a question of what that looks like, right, given current courts and given the willingness and the burden that this places on children to challenge these policies.
Right. Absolutely. Well, thank you so much for sharing your time and your perspective. It is really unique and I think incredibly valuable to this conversation. And I am so grateful to you for taking the time to share it with me.
It was such a pleasure. Thank you for having me.
Thank you.